First off, I'd like to express my gratitude to all of you for taking the time to listen to this presentation and to thoughtfully consider our views on the conflict in Gaza and also our reaction to the report that was issued today. And I'd like to thank the sponsors for giving me the opportunity to participate both in the assessment prepared by the generals and also in this event. My background was already explained, but I'd like to offer for you my personal motivation for being involved in this effort. I'm a passionate believer that war must be regulated by law, and that humanitarian law plays a vital role in mitigating the suffering of war. But I also believe passionately that the law must continue to manifest the inherent balance that's been central to its evolution since inception, which is a balance between military necessity and humanity. And so my concern is that when interpretations of the law distort that balance to one extreme or the other, it creates a false narrative of what the law requires. And warfighters in the future don't get often to choose the wars they're asked to fight. Their nations require them to do it, and we live in a very chaotic world. I think all of you recognize that the ability to predict whose military is going to have to be fighting what conflict in the next month or the next year or the next decade is impossible. But when these forces are asked by their nation or told by their nation to engage in hostilities they have a mission to accomplish in a very difficult environment against enemies who make that environment all the more difficult by their willful, deliberate, and systematic violation of the law. So my interest in this was to assist the generals in ensuring that their assessment reflected an accurate foundation of law. And they didn't need much help in that, to be very candid, because they had grown up in a culture that embraced compliance with the law, and they all had an intuitive instinct for the law. So a little polishing at the edges with terminology here and there was principally my function for the report that they prepared. My interest, whenever I see a report such as the one that was released today, was to look at it and ask myself, is this report accurately reflecting the true nature of both military operations that frames the application of law and the law itself? Because if it's not, and it's issued by an organization with the stature of the United Nations, then it can distort in the view of many others in the future what the expectation of law is in the conduct of military operations. And that distortion can have a debilitating effect, not only on the ability of armed forces to execute their mission, it can have a debilitating effect on their morale, because it creates this perception that no error is permissible in war, even a reasonable error, which is an unrealistic expectation. We tend to forget that the men and women who fight on behalf of democracies are moral human beings who come from a culture that respects life and are asked to do a very difficult and terrible function on behalf of their nations. And so distorting the reality of what the law demands from them can have a corrosive effect on their own understanding of their role in this dilemma, if you will. And ultimately, I think it distorts the fundamental function of the law to actually protect the civilian population. Because if we're not careful, what we do is we create a standard that actually incentivizes the exact bad behavior that endangers the civilian population. Because one thing is clear, no matter how illegal the conduct of an enemy may be in locating its vital assets in the civilian community or cloaking itself in the appearance of civilian, it doesn't eliminate the need of the military commander to execute the mission and accomplish the mission. So if we don't hold both sides accountable for their obligation to take measures to mitigate the risk to the civilian population, we're creating a false expectation that simply condemning the effects of combat will have a protective effect for civilians in the future, when in fact it has the exact opposite effect, because it encourages the enemy to create situations where a military that considers itself professional will have no alternative other than to engage in hostilities that produce that effect. So that's my interest, is to ensure that we understand that this balance has to be preserved. Now, I think the Commission's report deserves praise in the sense that it clearly recognized that what happened in Gaza was a conflict between two armed, organized groups, or maybe Israel, the IDF, and a group of armed, organized groups that were in a coalition. And that was an important point to start from, because that start point led the Commission to clearly indicate that all parties to that conflict bore an obligation to respect the law of armed conflict, or humanitarian law, whatever term you want to use. And we have to start there. This was not a conflict between an army and a group of civilians. This was a conflict between two belligerent groups. And as General Jones says, the generals who visited Israel noted that one of the interesting dynamics of this conflict was how it represents an evolution in non-state groups. We tend to think of non-state groups, insurgent groups, as completely militarily inferior to the states they're going to confront. And that's changing on a rapid basis. You just have to watch the news to see this. So this was a fight, this was a conflict, or in the very general sense, a war between two organized armed groups that were both bound to the laws of war. But at that point, I start to become concerned about the Commission's report, and particularly when I contrast it with the report that was prepared by these generals. So why do I have concerns, and what are the concerns? The why is because my concerns suggest that some of the conclusions, or many of the conclusions in the report, reflect an inaccurate understanding of the nature of military operations, and in some cases, an inaccurate understanding and application of the actual law that regulates military operations. So what are some of these flaws? First, I think there is some distortion of the controlling legal norms. The most notable example of this is what General Jones referred to already: the failure to clearly indicate that the distinction obligation is a dual obligation. It's not a unitary obligation on the attacking commander. The obligation extends to all parties to the conflict. All parties to the conflict have to take measures to mitigate the risk to the civilian population. The single most fundamental measure is to wear a distinctive emblem that distinguishes you from the civilian population, so that the attacking force is capable to effectively comply with its distinction obligation in the targeting process. And when an organization deliberately and systematically violates that obligation, it compromises the efficacy of the law's expectation that an attacking commander and an attacking force, an attacking soldier, can effectively draw those distinctions between civilian and combatant. Now, ironically, even in this context, fighting against an enemy that does, in fact, routinely and systematically violate this obligation, the IDF, in my view, and certainly in the view of the generals, took extraordinary measures to try and come up with solutions to this problem, and frequently at the expense of their own tactical initiative, and in many cases at the jeopardy of their own forces, by imposing rules of engagement that restricted the ability to use combat power until certain levels of certainty were established that the person you were directing your attack against was in fact a belligerent operative. But if the report fails to consider the impact of this systemic violation on the reasonableness of attack judgments throughout the campaign, and you can't divorce one from the other. You can't say that the attacking force has an obligation to distinguish the object of attack from the civilian population, or the object of attack from civilian property, without considering the fact that the enemy is deliberately and systematically violating its obligation for the specific purpose of complicating that distinction responsibility for the attacking force. So perhaps we shouldn't be surprised that a non-state group is disinterested in respecting this fundamental rule of law. That's one thing. But to ignore the effect of that violation on the broader assessment of compliance or non-compliance by the state party is extremely problematic, and I think undermines the legal foundation for many of the conclusions that the report reaches. I think that foundational flaw is also reflected in what the general noted, which is this, in the end, was a report that focused principally on the conduct of hostilities in close combat operations in an urban environment where you're fighting an asymmetric enemy that is highly capable, highly lethal, highly organized, but making no effort to respect the law. And to engage in that assessment without a solid foundation of military operational expertise to inform your judgments. And let me be clear, I'm not suggesting by any means that only a military professional is capable of making these judgments. But in terms of the factual foundation to support a judgment, you would think that the Commission would have a voracious appetite for the views of people like General Jones and the generals that accompanied him to Israel, like Colonel Kemp and the general officers that he's assembled on his group to assess the conflict. And yet in the report, all I've been able to see is one reference to a military expert who is not identified that assisted the Commission. We don't know what assistance was provided. We don't know the extent of the assistance. We don't know the nature of the opinions. And we don't know the background of this military expert. And I think that's very unfortunate. Because if a report like this is going to resonate with people in the profession of arms, they are going to look at the foundation in order to decide whether to give the opinion probative weight. Right? This is a basic axiom of opinions, right? The opinion is only as good as the foundation that supports it. So if you were to imagine that you were a general in the French army or the Danish army or the British army or you name it, and you got this report and you're looking at it trying to decide how significant of an influence this should be on my assessment of my future operations, consider how the fact that it was not sufficiently informed by military, not legal, military operational experts would influence your reaction to the report. And I think that's a flaw in the foundation. The other piece of this that I think is very troubling is the tendency to engage in what I've called effects-based judgments of military operations. And this is laced throughout the report. That our tendency is to look at the effects of combat and infer an ipso facto violation as a result of those effects. We saw it this morning in the presentation, actually. The terminology of massive destruction, overwhelming civilian casualties, the weighting of children casualties more than other casualties. This may sound, I hope it doesn't sound callous, but the reality is, if I'm advising General Jones, a civilian is a civilian. It doesn't matter whether it's a child or an adult. If it's a civilian, that's a protected individual, and we have to do everything feasible to avoid risk of inadvertent harm to that individual. But this kind of approach to the report suggests that what has happened is that because it is very difficult to recreate the tactical and operational situation that frames attack judgments, operational battlefield judgments. Why do you bulldoze a house? In the abstract, you can say a house is there and it's bulldozed. That looks awful. But if we don't back up and say, what was the mission? What was the enemy? What was the time constraint? What options did you have? What troops did you have available? What was the intelligence estimate on what was happening in that house? Was it booby-trapped? Were other houses booby-trapped? If you don't factor all of that into the equation, then you don't have the proper considerations to judge whether the effect you observe was in fact excessive or within the margin of appreciation that the law applies to a military commander in that complex situation. And yet what we tend to do, and I think what the report does frequently, is to rely on effects to draw an automatic conclusion or certainly a strong inference of illegality. That is extremely dangerous. Because imagine you're the non-state enemy. You are encouraged now and incentivized to create a tactical situation where the commander has no choice other than to produce the effect of destruction of civilian property and harm to civilian human beings, because you will take advantage of that by leveraging that as the touchstone of the immoral and illegal conduct of your opponent. And then the final piece of this that I think is so interesting is what I think is the failure to consider the kind of macro institutional commitment to the law or lack thereof to frame the way you approach individual incidents of potential violation. And by that, what I mean is when I look at the idea when the generals looked at the IDF, they looked at an institution that made an extremely significant effort to understand and implement the law of armed conflict through training, through the involvement of military lawyers in every phase of the operational planning, execution, and assessment process, through extraordinary use of precautionary measures related to the attack, even at the risk of tactical initiative, through decisions related to timing of attack, selection of weapons, etc., etc. At a macro level, I don't think anybody can claim credibly that the IDF is an institution that is indifferent to human suffering or doesn't care about the law. And I'm not surprised by that, because the reason professional commanders demand that their subordinates respect the law of armed conflict is not just because it produces an advantageous strategic information benefit. It's because it protects the moral integrity of the men and women they are entrusted to lead into combat themselves. They have to deal with this terrible situation of life and death judgments, and they have to come out of it morally whole at the other end. And commanders intuitively understand that demanding understanding and respect for the law contributes to the preservation of that moral clarity. On the other side, you had an organization that not only didn't care about the law, took it one step further. They exploited their violations of the law in an attempt to neuter the combat power of their opponent, because they knew full well exactly what I just said, that the IDF was an institution that was going to demand compliance with the law, even in the most complex battlefield situation. To take advantage of that, they endanger the civilian population. And ultimately, if we're not candid about that, and if we don't express that clearly and the effect it has on the execution of military operations, we conflate cause with responsibility. Just as the general said, we incentivize the worst practices, we increase the danger to the civilian population, and we devalue the efforts of legitimate military forces to deal with this complex and difficult environment as best they can. Thank you.